back, I'm Zane and you're watching Mind Your Business, where what we focus on grows. In today's video, I want to provide more clarity to my previous video while answering more questions regarding the filing of this beneficial ownership information report to cover the penalty fees involved, who must file versus who doesn't have to file, what's on the report, and who will be exposed to your information. But first, let me address this video.
All right, check it out. All this buzzing about the LLC people having to report this beneficial ownership information situation to the government, it's true, but it ain't like they say it is. I don't know where they're getting these extraordinary fees, these $500 a day and all these penalties for not filing after January 1st and all this whole kind of crap. The government is the most inefficient organization I've ever seen. They don't do nothing that fast. So, forget about that. Anyway, I did some research. First of all, I want to tell you, if you're going to go do your research, make sure you start at sites that end in .gov, not .com, because they don't know.
Now, if you're unaware, on January 1st of 2021, Congress passed the Corporate Transparency Act to crack down on unethical business dealings such as financial fraud of small businesses in the United States. And as a result, selected businesses will have to file what's called the Beneficial Ownership Information Report with the Financial Crimes Enforcement Network, better known as FinCEN, which is a bureau of the U.S. Treasury Department. And it is their belief that this will better help regulate and track all operational activities of small businesses in the United States, and the failure to comply will result in major penalty fees or even worse, imprisonment. And as stated on fincen.gov, and please feel free to pause the screen if needed, it states, the failure to report complete or updated beneficial ownership information to FinCEN may result in civil penalties of up to $500 for each day that the violation continues, or criminal penalties including imprisonment of up to 2 years and or a fine of up to $10,000. So again, this isn't something that I would take lightly. Now let's address who has to file versus who doesn't, because not everyone has to report. Simply, if you are operating as a company that has filed legal paperwork with the state to establish your entity such as an LLC or a corporation, whether you are a domestic entity formed in the United States or a foreign entity operating in the United States, you must file a BOI report. And this obviously does not apply to sole proprietorships or general partnerships. However, there are a total of 23 exceptions to those that don't have to file, which are listed here. But to note, the most common exceptions include large companies that have over 20 employees with gross receipts of $5 million, tax-exempt corporations such as nonprofits, and inactive entities. And let me touch more on nonprofits and inactive entities really quickly. As shown, if you registered a nonprofit through the state before January 1st of 2024, but haven't received your official tax exemption status from the IRS, you will be required to file a BOI report. However, once your tax exemption status is approved, you can file an updated BOI report to indicate such change. Now for inactive entities. If you formed a business prior to January 1st of 2020 and have no activity in your business, meaning you registered your business but aren't conducting any operations, nor have you been paid or received more than $1,000 in the past 12 months, you do not have to report. And if you formed any time after that date and don't have any plans to do anything with your business, I highly suggest filing what's called articles of dissolution with your local Secretary of State's department to close out your entity and avoid being penalized or future liabilities with the entity itself. Which leads to the next question. What information will be found on this BOI report? Such information that will be included entails your company's name and or trade name, your employer identification number, your company's physical address, which cannot be a P.O. box, so please do not include it as it would not be accepted, and the jurisdiction of where your company was formed. Also, you will be required to provide ownership information of the company to include names, birth dates, addresses, and your driver's license, as well as your passport if necessary, as well as an image of such documentation, which will all be filed electronically on fincen.gov. And now for the biggest question. Who will be exposed to your information? Again, this Corporate Transparency Act is all about monitoring your operational activities to crack down on unethical business practices. So the only agencies that will be exposed to your information, of course, includes FinCEN, as well as the U.S. Treasury Department, financial institutions with your consent, government regulators of financial institutions, Federal agencies engage in national security intelligence, law enforcement agencies with a court order, and foreign authorities requesting information through a U.S. agency. So please be aware that your information would not be exposed to the general public and will be kept confidential. So hopefully this all will provide more clarity, and if you have any more questions, I'll be happy to answer them below. Until next time.